Good afternoon, beautiful people of the great southern land and beautiful people of the world. It's Lucas here, broadcasting live from the Ark Sanctuary. I'll just wait for a few people to jump online. Please give me a comment and let me know that you can hear me okay. Please share this video as you're watching it. G'day Adam. So I won't be going through the comments much at all because I've got a fair bit to get through, and I'm going to try to, I'm not going to rush this because I want this to be correct and to come across in a way that people can comprehend what I'm saying with clarity, without doubt. Because it has come to my attention that Senator Malcolm Roberts has put out a video which I will play during this video, and I will point out the flaws and the lies in his video. Now, either Senator Malcolm Roberts is a disgraceful liar and a traitor to his country, or he is grossly incompetent to be in the position that he purports to hold, or both, which is what it appears to be. So I'll ask everyone who's watching now to share this video immediately. Hit the share button now, because we want this to get out to as many people as possible. Okay? We need you to share these videos because this is the only forum we have to get the truth out and to dispel the lies that they seek and purport to bring this country into demise. Okay? So please share this far and wide. One thing I'm going to address first and foremost. Someone sent me a personal message saying that they thought Malcolm Roberts was a Freemason. I can tell you that is in accordance with the principles of Freemasonry, Malcolm Roberts is not a Freemason. Even if he has sworn in to be a Freemason, he is not a Freemason based on his actions and his words, his lies and his dishonour to his country, to which he is supposed to swear full allegiance to. I won't talk about Freemasonry too much, but with regards to the principles of Freemasonry and actual Freemasonry, they are completely different to the quasi-fake Freemasons that you think you see today. So I'm going to play a bit of so-called Senator Malcolm Roberts lies to the public, and then we'll go through and dispel the nonsense.
Although it is unethical, unjustifiable, and a shocking intrusion on people's bodily integrity and human rights, the states have the technical legal power to mandate vaccines. The only solution is to tell them you oppose it, and if they don't listen, vote the wannabe tyrants out of power. Let's talk about some claims regarding mandatory vaccination. I completely oppose mandatory injections, but there are some false claims about their legality. Some people may not like the information I'm about to share with you, but I can assure you it's accurate. I wish it wasn't, but there is nothing to gain in misleading you and giving you false hope.
You're a liar.
Firstly, can the Commonwealth Government make COVID vaccinations mandatory? The Australian Constitution in Section 51, paragraph 23A, does not provide an authority for mandatory medical treatment on a person.
Truth.
That would include vaccination. It does allow the Commonwealth, though, to fund treatment, but not to compel it. Because the power to mandate treatment was not given to the Commonwealth under the Section 51, Clause 23A of the Constitution, the Commonwealth cannot mandate treatment under this provision. There are provisions in the Biosecurity Act 2015 made under the Commonwealth's quarantine power that in limited circumstances may authorise directions for individuals, but not for groups of people.
True.
The states, on the other hand, can mandate treatment if they pass legislation to that effect.
False.
Section 51, paragraph 23A of the Common...
Section 51, paragraph 23A of the Constitution. Let's read what that says. Section 51. The Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to Section 23A. The provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital benefits, medical and dental services, but not so as to authorise any form of civil conscription. Benefits to students and family allowances. Okay, not to authorise any form of civil conscription. Senator Malcolm Roberts agrees that the federal government cannot mandate compulsory immunisations. Let's carry on.
The Commonwealth Constitution does not restrict the states at the moment. Victoria and Western...
He says the Commonwealth Constitution does not restrict the states. Yes, the Commonwealth Constitution does restrict the states. And we'll get into that shortly. That's an outright lie.
Australia already have explicit legislation in place that could force a person to be vaccinated. There is nothing to prevent the other states and territories from passing similar enabling legislation to be in line with Victoria.
He's saying that Victoria has passed legislation that authorises the mandatory immunisation. Right? That legislation, to the extent of the inconsistency against the Commonwealth Constitution, is invalid, period. And we'll get into that shortly. Furthermore, there are other instruments and documents and acts that prohibit, including the Omnibus Act 2020, the COVID-19 Omnibus 2020 Act, that expressly state that the Human Rights Charter of Victoria is valid and not to be conflicted with. We'll carry on.
In Western Australia. The result of that is that if the Prime Minister can persuade the states and territories to follow his line, they can enable the Commonwealth demands. Is this morally right? Absolutely not. It would be a backdoor way for the Commonwealth to sneak around the Constitution on enforcing injections. Scott Morrison can't do it because of the Constitution. So he's getting the state governments to do his dirty work. Another issue that requires some explanation is the effect of Section 109 of the Australian Constitution.
If Scott Morrison is barred from doing it because of the Constitution, so are the states. And he's going to talk about this. He's going to give his interpretation, his incorrect interpretation. And pay close attention to the words he uses right now when he refers to Section 109. And I'm going to point out, point blank, beyond reasonable doubt, the lies that he is spreading. Now, the words in the statutes and acts, as I've been speaking about for months now, the words are imperative. The words are extremely significant because they are, the language used in the statute is the intention of Parliament. Okay? So when he puts different words into what the Constitution actually says, he's point blank lying. And he's trying to alter the Constitution off his own bat.
Constitution. This says that if there is a conflict between a valid Commonwealth Act and a valid State Act, the Commonwealth Act shall prevail to the extent of any inconsistency. Although it is unethical, and Australia already have...
So what he's just said there is he's tried to diminish the wording of Section 109. Let me just find that again and replay that.
Explicit legislation in place that could force a person to be vaccinated. It would be a backdoor way for the Commonwealth to sneak around the Constitution on enforcing injections. Scott Morrison can't do it because of the Constitution. So he's getting the state governments to do his dirty work. Another issue that requires some explanation is the effect of Section 109 of the Australian Constitution. This says that if there is a conflict between a valid Commonwealth Act and a valid State Act, the Commonwealth Act shall prevail to the extent of any inconsistency. Some people...
Right. A Commonwealth Act and another Act. Blah, blah, blah. Right, he's just changed the words of the Constitution. I'm going to read what it actually says in fact. Once I get my screen clear. Section 109 of the Constitution. This is what it reads word for word, verbatim. Not his interpretation of what it says. He's a liar. Section 109. Under inconsistency of laws. When a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. Period. Do you see how he's tried to change the words around? Now again, if you're watching this, if you've just come on, please share this now as you're watching so we can get as many people on and sharing this video, because this needs to go viral. I'm pointing out the lies that this man is saying. Right? So when a law of a state is inconsistent with a law of the Commonwealth, not an act, a law, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. Furthermore, subsection 450, which defines the term when a law of a state is inconsistent, in quotation marks. When a law of a state is inconsistent, our analysis and explanations of sections 106, 107 and 108 render it unnecessary to elaborate on section 9, which is practically a corollary to the three preceding sections. Section 106 provides that the constitution of each state is to continue subject to the constitution of the Commonwealth. The constitution of the states is where they get their legislative power from. That is the source and fundament and foundation of their authority, as is the federal constitution for the federal government. That is the source and foundation of their authority to govern. Okay? So section 106 provides that the constitution of each state is to continue subject to the constitution of the Commonwealth. That means it is beneath the constitution of the Commonwealth. Section 107 provides that the power of each state parliament is to continue subject to the constitution of the Commonwealth. Okay? The power of each state parliament is to continue subject to the constitution of the Commonwealth. That expressly states its power is below the constitution of the Commonwealth. That cannot be interpreted in any other way. Section 108 provides that every law in force in a colony is to continue subject to the constitution of the Commonwealth. The consequence of this subjection of state constitution, state parliamentary power, and state law to the federal constitution would have been obvious without the insertion of section 109. That section, however, places beyond doubt the principle, the highest, the principle that the federal constitution and the laws passed by the federal parliament in pursuance of the constitution prevail over the state constitutions and the state laws passed by the state parliaments in pursuance of the state constitutions. The latter laws, however, are declared to be invalid only to the extent of their inconsistency with the former. Now, the Senator correctly stated that the Commonwealth Parliament does not have a right to mandate immunisations. The Federal Parliament receives their authority from the Constitution. The state parliaments are subject to the federal constitution first and foremost, and then they have authority to pass residual laws. They have residual power. Therefore, in accordance with the Senator's statement that the Commonwealth Parliament, the Federal Parliament, according to the Commonwealth Constitution, does not have power to pass laws regarding mandatory immunisations, in accordance with Section 106, 107, 108 and 109 of that Federal Constitution, which place the states under the Federal Constitution, the states cannot mandate immunisations. A law of the Commonwealth means a valid law. That includes the common law. A law passed by the Federal Parliament outside the scope of its authority would be no law at all. Yep, we know that, and that applies to the states as well. Okay? We're going to get into the common law and those sorts of things as well. We're going to talk about that constitutionally. But of what I've just read, and that's just a fraction of what I'm going to go into, of what I have just read, he has admitted that the Commonwealth Parliament has no authority to pass laws for mandatory immunisations. Therefore, the state parliaments have no authority to pass laws for mandatory immunisations. Period. There is no interpretation. It cannot be interpreted any other way. It is clear as day. It is indisputable. Okay? But I have much more goodies to go through. I'm really enjoying picking this parasite apart.
People believe this makes mandatory vaccinations illegal, even if the state does them.
That's right.
The Constitution, however, is a special document, not being a Commonwealth Act, and Section 109 does not apply in the context of mandatory treatments. If there was a Commonwealth Act saying vaccinations are not to be mandatory, and a state act saying that vaccinations are mandatory...
Right. Senator Malcolm Roberts has just stated publicly to his constituents that it's not a Commonwealth Act. What is it then? Because if we look at, well, this one to start with, I've got about 4 constitutions here. This is the Australian Constitution. Commonwealth of Australia Constitution Act. An act to constitute the Commonwealth of Australia. And I can go on and read more and more where it keeps saying it's an act. This man is lying through his teeth. Point blank. Any person with a set of eyes who knows how to read words on a page can get one of these books. Yep, they're free from your Federal Parliament office. I implore you to go and get one of these at a minimum. Yep. It also explains Section 109, which again proves him to be an absolute liar. It explains Section 51. So go to your Federal Parliament office and get your free copy of this little thing, or order one of the red ones off Wayne Glue, one of the green ones, one of their corporate ones off the internet. All say the same thing regarding the mandatory vaccines and Section 109 and Section 106 and 107 and 108 that verify what I've just said to you. Right? Or you can get a LexisNexis Concise Australian Legal Dictionary online that also has the sections of the Constitution. It does not have the annotations that explain the definitions of what they mean, but it has the sections in them. All the Australian law dictionaries do, and I highly recommend you get at least one of them. Right? So what is he saying now?
The State Act would be inconsistent with the Commonwealth Act, and the State Act would fall under Section 109. However, there is no Commonwealth Act that says vaccinations cannot be mandatory.
We just heard that's a
So
lie.
Section 109 does not apply. Now, there may be a number of human rights...
Commonwealth Constitution is an act. It's a Commonwealth Act, as it states explicitly and expressly. Okay? I'm just going to take a breath, because just listening to the lies coming out of this thing's mouth irritates me greatly. So if you've just tuned in, please share this video so we can get more people watching and sharing this information as soon as possible. And I've only just scratched the surface. Right. Let's have a bit of fun, shall we? I really love this section. It's my favourite number, number 33. Subsection 33, right, clause 5. Clause 5. Operation of the Constitution and laws. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state, and the laws of the Commonwealth shall be in force on all British ships. Yeah, that's your Admiralty courts. The Queen's ships of war excepted. Yep, that's why you can't use your Constitution in those Admiralty courts, the Queen's ships of war. Whose first port of clearance and whose port of destination are in the Commonwealth. That's talking about her ships of war. Yep, her Admiralty courts. Okay. Subsection 33. This is where it defines and all laws. Okay? Actually, just before I go on with that, I just want to explain by the Australian Law Dictionary the definition of the Constitution. Constitution. The form of the supreme government in a state. The fundamental set of rules governing matters pertaining to its organisation, including delineation of the powers of its separate organs and the rights and duties of its citizens, whether consolidated in one document, unconsolidated, or even, now rarely, unwritten. Where the Constitution is established by a written instrument, as in Australia, that instrument is called a constitution. This is a document or statute laying down fundamental foundational rules of government, and it may be entrenched or unentrenched. It is generally only changeable in accordance with certain strict procedures. That would be section 128, which requires a referendum to alter the Constitution. A referendum is when the law must be passed to the people, to the voters, for deliberation and for the voters to make their decision. If it does not go to a referendum, it is not valid because it has not been changed in accordance with the supreme law of the Parliament of the Commonwealth of Australia, being the Constitution, which is where they derive their power from, without which they have no power nor authority. Right. Subsection 33 of the Constitution, where it defines and all laws. Not all enactments purporting to be laws made by the Parliament are binding, but laws made under, in pursuance of, and within the authority conferred by the Constitution, and those only are binding on the courts, judges, and people. Those only. So every single law that conflicts with the Constitution is invalid and is not binding on the people. Period. A law in excess of authority conferred by the Constitution is no law. It is wholly void and inoperative. It confers no rights. It imposes no duties. It affords no protection. Pay attention, public officers. The act itself is binding without limitation or qualification because it is passed by the sovereign parliament. But the laws passed by the Parliament of the Commonwealth, a subordinate parliament, must be within the limits of the delegation of powers or they will be null and void. There are two Commonwealths, as per subsection 444 and the definition of Commonwealth of Australia in the law dictionaries. What is not so granted is either reserved to the states, unless of course it is expressly prohibited in the Constitution. What is not so granted is either reserved to the states, as expressed in their respective constitutions, or remains vested but dormant in the people of the Commonwealth. Let's continue on with a bit more fun. Oh, I love this one. This is section 55, subsection 253. The very principle of the Federal Constitution is this: that the Constitution is above both houses of Parliament. That is the difference between it and our houses of Parliament now. The Federal Constitution must be above both houses of Parliament and they must conform to it. Because it is in the Charter under which union takes place and the guarantee of rights under which, because it is in the Charter under which union takes place and the guarantee of rights under which union takes place, and unless you have some authority for them to interpret that, what guarantee have you preserving their rights at all? They're talking about your rights. That's why both houses of Parliament and the government, state and federal, are all under the Constitution, and it can only be amended through section 128 by the voters of the Commonwealth of Australia. Parliament is not supreme, and the very essence of the Federation is that it should not be so. Parliament is not supreme, and the very essence of the Federation is that it should not be so. Parliament, as far as constitutional questions are concerned, is under the law and it must obey the law. Period. Then we have the question, right? These states, foreign corporate entities. Yep. That's why they're not abiding by the Constitution. But we'll look at foreign corporate entities. What does it say about corporations and entities? Right, subsection 182, section 51, 13. Where an act of incorporation does, what an act of incorporation does is to create a legal and artificial person with capacity to carry on certain kinds of business, which are defined within a defined area. But it may nevertheless be subject in carrying on that business to the law of the locality wherein it does so. That means even the corporations are subject to the Commonwealth Constitution because that is the law of the land where they do so. Okay? Furthermore, section 51, 20, subsection 195. Foreign corporations chartered for lawful purposes have the right to carry on business within the British Dominions, subject to the conditions and requirements of local laws. This has been recognised by the Commonwealth of Nations as well as by conventions concluded between Great Britain and other countries. In short, foreign includes every corporation established beyond the limits of the Commonwealth. Corporate Commonwealth entities are separate legal entities, as per the Public Governance, Performance and Accountability Act 2013. I think it's that act. But corporate Commonwealth entities are legally separate from the Commonwealth. They are subject to the Commonwealth Constitution. Let me just cross a couple of these off. Done that. Section 71, page 719, 721. Rightio. Let's have a little bit more fun. We're at section 71 of the Constitution, chapter 3, the Judicature. Subsection 286, talking about legislative encroachments. The legislative power extends only to the making of laws, and in its exercise it is limited and restrained by the paramount authority of the federal and state constitutions. Remember, the state constitutions are subject to the federal constitution. And if their laws conflict with the federal constitution, they are invalid. It cannot directly reach the property or vested rights of the state, It cannot directly reach the property or vested rights of the citizen by providing for their forfeiture or transfer to another, without trial and judgment in the courts. For to do so would be the exercise of a power which belongs to another branch of the government, and is forbidden to the legislative. So what they're trying to do, that's why the Biosecurity Act says that they must have an order on an individual, a biosecurity order, in order to quarantine that individual. They cannot quarantine and punish the entire population. They must have a court order, because they cannot take away your rights without a court order. The legislature does not have power to do that, state or federal. If the federal doesn't have it, the state certainly doesn't have it. Right? I'm going to talk common law. Right, subsection 341, section 79. Any law of the Commonwealth. The phrase, any law of the Commonwealth, includes in the first place the Constitution itself. Right? So Malcolm Roberts, you're wrong again, mate. This phrase, the phrase, any law of the Commonwealth includes in the first place the Constitution itself, which is not only a law of the Commonwealth, but in a sense, and with the reservation of the supremacy of the British Parliament, may be called the supreme law of the Commonwealth. It includes in the next place the laws of the Federal Parliament, which together with the Constitution are binding on the courts, judges and people of every state and of every part of the Commonwealth. Common law. So far as the common law can be relied upon by the Commonwealth and in relation to the affairs of the Commonwealth, it would seem to be equally with federal statutes, this is common law we're talking about, the law of the Commonwealth. I'm going to read that line again. So far as the common law can be relied upon by the Commonwealth and in relation to the affairs of the Commonwealth, it would seem to be equally with the federal statutes, the law of the Commonwealth. Common law, that's a big one. Yep. Forgive me if these seem a little bit disjointed, but the information is what it is. Quickly read section 92 of the Constitution. Section 92. On the imposition of uniform duties of customs, trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Right? Then we go to the elements of interstate free trade, subsection 389. In reference to the first question, absolute freedom of trade, commerce and intercourse may be defined as the right to introduce goods, wares and merchandise from one state into another, the right to sell the same, and the right to travel unburdened by state restrictions, regulations or obstructions. Unburdened. Travel unburdened. Right? I'm just going to quickly go to the Omnibus Act. If I can find it. With that many documents and books, and I only have a small space. COVID 19 Omnibus Emergency Measures Act 2020, Section 38. New Part 9 inserted. Part 9, Temporary Measures in Response to COVID-19 Pandemic. Purpose and effective part. The purpose of this part is to temporarily change the operation of this Act in response to the COVID-19 pandemic. Subsection 2. This part applies despite anything to the contrary in another part of this Act or any other Act other than the Charter of Human Rights and Responsibilities or the Constitution Act 1975 or any subordinate instrument other than a subordinate instrument made under the Charter of Human Rights and Responsibilities, or any other law that includes the common law, includes the Constitution. Right? So, even the Omnibus Act cannot conflict with any other law, nor the Charter of Human Rights and Responsibilities Act 2006 Victoria, which states that you can't be subjected to forced medical experimentation or medical treatment without your consent. I think that's Section 10 of the Charter of Human Rights and Responsibilities Act 2006 Victoria. Right. Let's see what that old mate had to say about human rights.
Actions against forced vaccination, but these have not yet been fully tested under Australian law. Some people have raised the Nuremberg Code, which is an international agreement that says that people should not be subject to experimental treatment unless they have consented to that treatment.
Well, actually, that's a document stating what medical doctors cannot do.
It's only enforceable in Australia if it's in legislation, which is not the case, apart from the ACT, where Section 10, Paragraph 2 of the Human Rights Act 2004 provides the right not to be subject to medical treatment or experimentation without free consent.
Lies.
The Nuremberg Code is a principle that should be adhered to ethically, but it's not a guaranteed legal requirement generally in Australia. Forced vaccinations represent an attack on bodily integrity, and without a valid consent may well constitute an assault. People should be able...
Well, let's talk about human rights briefly. Okay. This is the Oxford Australian Law Dictionary. Human rights instruments. Australia is signatory to several instruments relating to human rights. For example, the Race Discrimination Act 1975, Commonwealth, incorporates the International Convention on the Elimination of All Forms of Racial Discrimination, 5 international covenants on civil and political rights are incorporated in the Human Rights and Equal Opportunity Commission Act 1986, Commonwealth. 5 international covenants on civil and political rights are incorporated in the Human Rights and Equal Opportunity Commission Act 1986, Commonwealth. So that would be a Commonwealth document, yeah? That would be a Commonwealth Act, Mr. Malcolm Roberts. Okay? They include Convention Concerning Discrimination in Respect of Employment and Occupation. You'd probably want to look that one up if your job is in question because of your choices. International Covenant on Civil and Political Rights, ICCPR. Declaration of Rights of the Child. Declaration of the Rights of Mentally Retarded Persons. Declaration of the Rights of Disabled Persons. Right, so if the International Covenant on Civil and Political Rights is incorporated in the Human Rights and Equal Opportunity Commission Act 1986 Commonwealth, that would be a Commonwealth Act, would it not? Let's have a look at the International Covenant on Civil and Political Rights and what it says about non-derogable rights during a state of emergency. Article 4, International Covenant on Civil and Political Rights. Article 4.1. In time of public emergency which threatens the life of the nation and the existence of which is officially proclaimed, the states party to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, colour, sex, language, religion or social origin. 2, subsection 2 of Article 4. No derogation from Articles 6, 7, 8, paragraphs 1 and 2, 11, 15, 16 and 18 may be made under this provision, right? So what that says is that no derogation, they cannot take away rights as given in Articles 6, 7, 8, 11, 15, 16 and 18, right? In a time of public emergency, they can't take away from these rights. Okay? Article 7 expressly states, no one shall be subjected to torture or to cruel, inhumane or degrading treatment or punishment. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. Right? That is expressly stated. That is, what are the words you use? Incorporated in the Human Rights and Equal Opportunity Commission Act 1986 Commonwealth, making it a Commonwealth Act. The Victorian Charter of Human Rights and Responsibilities 2006, Section 10, I believe. Section 10, Charter of Human Rights and Responsibilities Act 2006. Protection from torture and cruel, inhumane or degrading treatment. A person must not be A, subjected to torture. Yep, being locked in their house, that would classify. Or B, treated or punished in a cruel, inhumane or degrading way. Or C, subjected to medical or scientific experimentation or treatment without his or her full, free and informed consent. That is expressly stated in the Charter. That's a Victorian Act. So now you've got the Commonwealth Act bringing in the International Covenant on Civil and Political Rights. Then you have a Victorian Act. You also have a Human Rights Act in the ACT, right? So, Malcolm Roberts, you don't know what you're talking about, mate. You're lying to your people, or you are grossly incompetent to sit in the public office you hold. Or both. I think both. Right? We don't care about your opinions and your beliefs. We care about the law and our rights and what it says. And you, sir, are completely incorrect and incompetent. Period. Furthermore, Article 18 of non-derogable rights of the International Covenant of Civil and Political Rights. Yep, as incorporated in that Commonwealth Act I mentioned before. Article 18, subsection 1. Everyone shall have the right to freedom of thought, conscience and religion. This right shall include freedom to have or adopt a religion or belief of his choice, and freedom either individually or in community with others, and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching. In public or in private. International, this is the Australian Law Dictionary, Oxford. International Covenants on Human Rights. There are 2 international covenants on human rights which, along with the Universal Declaration of Human Rights 1948, make up what is known as the International Bill of Rights. They are the International Covenant on Civil and Political Rights 1966, which we just heard of, and the International Covenant on Economic, Social and Cultural Rights 1966. both of which entered into force in 1976. International law. The law and legal relationships that apply across legal boundaries. International law encompasses both the relationships between states, in brackets, public international law, and the relationships between private entities and between private and state entities. Private international law. Right? So the international law, the International Covenant on Civil and Political Rights, the Universal Declaration of Human Rights, is governing the relationship between the state and the individuals. The Charter of Human Rights and Responsibilities Act 2006. And before I finish this video, I'm going to get into the constitutional parental rights, which means that the government, the parliaments, the state or the federal governments have no rights to decide what goes into your children or onto your children's body, period. Charter of Human Rights and Responsibilities Act 2006, Section 1, Purpose and Citation. This is the purpose. Subsection 2C, imposing an obligation on all public authorities to act in a way that is compatible with human rights, and requiring statements of compatibility with human rights to be prepared in respect of all bills introduced into Parliament, and enabling the Scrutiny of Acts and Regulation Committee to report on such compatibility. Interesting how the Omnibus Act 2020 Emergency Measures Act expressly states that the Charter of Human Rights and Responsibilities Act Victoria is not to be deroged from. Right? It stands. So do all other laws, including Commonwealth, federal law, the Commonwealth Constitution, including the common law. Okay? But note in Section 6, let me not be too biased here. Note in Section 6, corporations do not have human rights. This is why it is imperative when you are dealing with these public officers that you are not handing over your state identification because they are intimidating you to do so. Because then you are purporting to be a part of that corporation. If you hand them over state identification, you are purporting to be part of that corporation. If they coerce you to give them a name, you give them your first name and your middle name, yep, and your family name, and you expressly state as you're videoing it that they are to be written in all lowercase letters, because you are not contracting with them. You are a man or a woman acting under your common law right, and you require them to act under their common law duty. Right? Make sure you record this stuff. Because once they force you into a contract, that is slavery. And that is against Article 8 of the International Covenant on Civil and Political Rights, which is also a non-derogable right during a state of emergency. They cannot force you into slavery. And by forcing you to give a corporate name, or writing it down as a corporate name, or forcing you to give a corporate instrument such as a driver's license, they are forcing you into slavery. Right? Section 8. Every person has a right to enjoy his or her human rights without discrimination. Privacy and reputation. Section 13. A person has the right not to have his or her privacy, family, home or correspondence unlawfully or arbitrarily interfered with, and not to have his or her reputation unlawfully attacked. Freedom of movement. Section 12. Every person lawfully within Victoria has the right to move freely within Victoria and to enter and leave it and has the freedom to choose where to live. Right? This Act, the Charter of Human Rights and Responsibilities Act 2006 Victoria, stands above the Omnibus Emergency Measures Act. The right to liberty and security of the person. Section 21. Everyone has a right to liberty and security. A person must not be subjected to arbitrary arrest or detention, as we are seeing happening all over the country. A person must not be deprived of his or her liberty except on grounds and in accordance with procedures established by law. The acts, the directives that these people are following are not established by law. Right? Furthermore, this one's really good. What section is it? Section 21, subsection 8. A person must not be imprisoned only because of his or her inability to perform a contractual obligation. So when the police or public officers are arresting you because you will not provide them with a corporate state document claiming to be a part of their corporation, which you have every right not to do, right? They cannot imprison you because that is merely what they would classify as a contractual obligation to provide your identification or your name when you haven't committed an offence, right? When you haven't committed a crime, you haven't harmed somebody, they haven't witnessed you harm somebody or destroy somebody's property, period. The acts they are enforcing are private acts of Parliament. They are contractual acts. They apply only to employees of their corporation, period. Right, section 32. So far as it is possible to do so consistently with their purpose, all statutory provisions must be interpreted in a way that is compatible with human rights. Must be interpreted in a way that is compatible with human rights. Well, the Omnibus Act says that the Human Rights Act still stands and all other laws still stand. Right? Therefore, those public officers must interpret those statutory provisions in a way that is compatible with those human rights, as well as the International Covenant on Civil and Political Rights. Yeah, that covers everybody in Australia, by the way. Yep. As well as the Universal Declaration of Human Rights. Yep. Subsection 2 of Section 36 of the Charter of Human Rights and Responsibilities Act 2006 Victoria states that international law and judgments of domestic, foreign and international courts and tribunals, that would be the Nuremberg Code, Mr. Malcolm Douglas, international law and judgments of domestic, foreign and international courts and tribunals relevant to a human right may be considered in interpreting a statutory provision. So every single law, every single international law, every single domestic law, every single Commonwealth law, even their own Omnibus Act clearly, expressly states, that they have not got the power or authority lawfully to do what they're doing, and that they must comply with the human rights. Period. Especially when it comes to medical experimentation. The Chief Health Officer came out on national television and told you people that these injections are an experimentation. He did not mix his words. He was direct with you. He told you. In fact, all of those people that are speaking on TV, those politicians, seem to be letting it slip that the immunisations are the danger. Pay attention to what they say. They do not mince their words. They do not make mistakes. Everything they say is deliberate. They are giving you full disclosure. Therefore, I don't have a problem with what they're doing because they're not really lying. But Malcolm Roberts, you're a liar. And I don't like liars. I despise liars. Right? Personally, I'm unbiased as to how many people decide that they want to go and take this experimental jab. The more that want it, the merrier. Go and have it. I don't care. But as soon as you start lying and trying to force the people that don't want it, you've got a big problem on your hands. Right? Such is the law of free will. God endowed us all equally with a brain. So we can make our own decisions. Okay? So feel free to advertise your jab and whatever you want to do. I don't give a shit. Give it to as many people as want it. Fucking good on them. But don't start lying, coming on social media and on TV and lying about the law. Because the law is what it is. And no one abides liars. It's dishonourable, and you do not deserve, you will not be in the position you're in any longer. You're a disgrace. Right, Subordinate Legislation Act 1994. Human Rights Exemption Certificate means a certificate issued by the responsible minister in relation to a proposal, statutory rule, blah, blah, blah. See Omnibus Act. You have already explained the Omnibus Act. Right, the Public Administration Act 2004. Public Administration Act 2004. Okay? Human rights. This is Section 7. Section 7, public sector values and employment principles. Principle is the highest thing that you must abide by. That is the top rule, okay? Public sector values and employment principles. Section 7. Subsection G, human rights. Public officials should respect and promote the human rights set out in the Charter of Human Rights and Responsibility by I, making decisions and providing advice consistent with human rights, and actively implementing, promoting and supporting human rights. Oh, this is for all the ministers in charge. Section 8, subsection 2, subject to subsection 3 and 3A. A public sector body head must promote the public sector values to public officials employed in the body and ensure that any statement of values adopted or applied by the body is consistent with the public sector values. That would include human rights, but not limited to human rights. So it is your job as a public sector body head to ensure that your minions, your agents below you, are acting in accordance with human rights. Furthermore, Section 8, Public Sector Employment Principles. Subsection Charlie Alpha, CA. Human rights as set out in the Charter of Human Rights and Responsibilities are upheld. Right? So, public sector body heads must establish employment processes that will ensure that human rights as set out in the Charter of Human Rights and Responsibilities are upheld. And public sector employees have a reasonable avenue of redress against unfair or unreasonable treatment. That means if you are working in the public sector body, right, and they want to force you to have something that you don't want to have and force you to do something that's against the law that they can't do, right, your boss must make sure there is a reasonable avenue of redress against unfair or unreasonable treatment. Yep. Or they must be sacked immediately. Right, the Subordinate Legislation Act 1994, preparation of legislative instruments. Section 12D, Human Rights Certificate, legislative instruments. The responsible minister must ensure that a human rights certificate is prepared in respect of a proposed legislative instrument unless the proposed legislative instrument is exempted under subsection 3. Right, so we go back to the COVID Omnibus Act, Emergency Measures Act 2020, and expressly states that the Charter of Human Rights and Responsibilities Act, the Constitution, and any other law, including the common law, must be followed and upheld, right? Or provide a human rights certificate as to why it is not to be done so. But when it's expressly stated that it is, then it is. Yep. Okay. And common law in every situation, yep, unless expressly stated in express words in the statute, common law overrides statute law. Okay? We'll go to the principle of statute law supremacy. The overriding effect of statute law over common law. Statute law supremacy operates subject to the presumption that in the absence of clear statements to the contrary, legislation does not override fundamental common law rights. Okay? So, where it is expressly stated that it is not to override any other law or the human rights, any other law including the common law, yep, as per the Constitution, is equal to federal statutes, yep, then your statute is invalid if it tries to override a fundamental common law or the common law at all. Right? The right to personal liberty. This is a fundamental common law right. Right to personal liberty. This is the Concise Australian Legal Dictionary, 4th edition. Also known as the right to liberty and security of the person. This is the fundamental right not to be subjected to arbitrary arrest or detention, nor deprived of freedom except and in accordance with procedures established by law. Procedures established by law means it must be passed through Parliament. Yep. If it conflicts with the Constitution, before it's passed through Parliament or after it's passed through Parliament, it must be put to a referendum of the people. Yep. Not a coerced, forced, covert referendum. Must be put to an open vote. Right? Because anything done under duress, which is what you're putting the people under, anything done under duress, I think it's Section 58 or Section 9AG of the Crimes Act or the Wrongs Act 1958, anything done under duress is not the act of the person doing it. Okay? Right to personal liberty, also known as the right to liberty and security of the person. This is the fundamental right and not to be subjected to arbitrary arrest or detention, nor deprived of freedom except and in accordance with procedures established by law. International Covenant on Civil and Political Rights, 1966, Article 9. Universal Declaration of Human Rights, 1948, Article 3. The right to personal liberty in Australia is a fundamental common law right. That's Foster v. R. 1993. That's a precedent already set. Okay? Also see Human Rights Act 2004, ACT. Yep. And Charter of Human Rights and Responsibilities Act 2006, Section 21. Okay? Parental rights. I want to get into this one. Parental rights. Right, Section 51, the Commonwealth Constitution. Section 51, 22. Divorce and matrimonial causes, and in relation thereto, parental rights, and the custody and guardianship of infants. The definition under subsection 203 of parental rights this is where it defines parental rights as per the Constitution. The Parliament has power to legislate respecting the rights of parents to their children, but only in relation to divorce and matrimonial causes. Period. Right? Outside and independent of the area covered by divorce and matrimonial causes, the power of the state to deal with parental rights remains unaltered. They have none. Okay? The government cannot tell you what you must do with your children. Period. According to the Constitution, that is. Okay? I'm going to read that one again. Parental rights. Subsection 203 of Section 51, subsection 22. Correction, Section 51, XXII, 22. Right, subsection 203, parental rights. The Parliament has power to legislate respecting the rights of parents to their children, but only in relation to divorce and matrimonial causes. Outside and independent of the area covered by the divorce and matrimonial causes, the power of the states to deal with parental rights remains unaltered. The reason they have a right to deal with them with regards to divorce and matrimonial causes is because when you consent or you go into a court, right, to get a decision made about your children, right, you come to an agreement or the court makes a decision, right, you get to have your children for this long and they get to have your children for that long, right? That's it. Matrimonial and divorce, okay? They can't tell you what to put in your children or what not to put in your children or what to put on their face. It's child abuse. Nuremberg Code. The 10 elements of the code are voluntary consent is essential. I had another document here, if I can find it. God knows what I've done with it. I need a bigger office. I need more space. I need electricity. I keep asking people to put me in a place where I can do my work from because this doesn't cut it. But anyway, enough complaining. The 10 elements of the code, the Nuremberg Code. Voluntary consent is essential. Yep, that aligns with the Human Rights Declaration, the International Covenant on Civil and Political Rights, the Victorian Charter for Human Rights, the Human Rights Charter of the ACT, yep, and all the other ones, right? The results of any experiment must be for the greater good of society. Human experiments should be based on previous animal experimentation. Experiments should be conducted by avoiding physical, mental suffering and injury. No experiment should be conducted if it is believed to cause death or disability. Well, we know that these jabs are killing people and disabling people. That is an indisputable fact, right? The risks, 6, the risks should never exceed the benefits. 7, adequate facilities should be used to protect subjects. 8, experiments should be conducted only by qualified scientists. 9, subject should be able to end their participation at any time. Yep. So if you want to end the experimentation of the Hive flea towers that they're microwaving you with, probably stop paying your bills, yeah, your phone bills. Because every time you pay your phone bill, right, for that buddy, you know, that G5 service, you're agreeing. A payment is agreement. So when you're paying for your phone bill and your internet service, you are agreeing to using that G5, okay? Stop paying for it. Let them take it down. And subjects should be able to end their participation at any time. That means if you don't want to participate in a forced immunisation, an experimental forced immunisation as explained by the Chief Medical Officer on national television, then you can leave it at any time, all right? And 10, the scientist in charge must be prepared to terminate the experiment when injury, disability or death is likely to occur. Yeah, well, that's already occurring, so feel free to end it at any time, mate. Even if they end it now, millions are going to die, period. So I think that's really all I've got to go through at the moment. Try and keep it as short as possible. I know there's a lot of information packed into there. I keep asking for people to focus and to get a place where I can get with a team and put some paperwork together, because at the moment it's all everywhere. I can't do anything. I don't have power to print. I don't have power to charge my laptop. I've got no power to do anything. All right? If you really want this to move forward, you're going to have to get people, you're going to have to dig deep and put a place together where people can come together who are willing to work and put this stuff where it needs to be, yep, in order to help you people, right? Otherwise, just keep going your way the way it is. I'm doing this video because Malcolm Roberts, you're a liar, and I can't stand liars. If I didn't see that video, I'd be sitting on my ass watching videos today. But anyway, there's a lot more information and a lot more knowledge and a lot more technicalities that bring this whole thing together, right? It diminishes everything they say and everything they lie about, okay? But it can't be done from here. Anyway, thanks for watching. Please share this video. Please share it. Please share it. Please share it. I can't stress that enough. You've really got to share this on every forum you can, any forum you can, okay? Get it out there. Smother their lies with the truth, all right? Much love. Many blessings from me and Star at the Ark, and we'll talk to you all again soon. Please share. Share. Share.